In this lesson, we're going to carry on talking about the nature of presumptions and burdens as they pertain to criminal evidence, and focus on the impact of human rights in relation to this particular area of the law. Now, there's some implications that are associated with Article 6 of the European Convention on Human Rights. Article 6, of course, concerns itself with the right to a fair trial. And we'll see how this impacts the nature of burdens of proofs and presumptions of innocence. And we'll talk about a couple of cases that have taken place sort of inside the law of the ECHR, a case against France, for example. And then we will also focus on cases associating the nature of Article 6 in with English legal systems as well, within the basic nature of the presumption of innocence as it pertains to the English law as well. So, essentially, this is probably one of the most extensive areas of reform that we see when we look at the impact that the Human Rights Act, specifically in terms of its domestic incorporation, but more generally the ECHR, the impact that the ECHR has had over the law of evidence and the law of criminal evidence. Obviously, Article 6 is the thing that you're going to be spending the most of time thinking about, because Article 6, of course, concerns the right to a fair trial. And essentially, there has been a number of major reforms that have sort of become part of the English legal system as a result of the Human Rights Act, specifically incorporating the convention rights from the ECHR into English law. So, how do we associate this then? What do we think about when we look at the nature of the presumption of innocence as it relates to the ECHR? Well, the idea of and the concept of there being a presumption of innocence within the criminal trial is expressly enshrined in the European Convention, in specifically Article 6.2 of the European Convention, where it says, quote, "Everyone charged with a criminal offence shall be presumed innocent until proven guilty according to law." A very basic idea here, a very basic principle of the rule of law. The idea essentially being that if you are charged with a criminal offence, you are going to be presumed innocent until proven guilty according to law. This is the basic golden thread that we noted in previous lessons from the case of Warburton versus the Director of Public Prosecutions. The case, of course, concerning the individual who went and had shot his wife, his ex-wife, or at least his wife who had become separated at the time. And while the trial judge and the courts suggested that the case is obviously so strong against Mr. Warburton, Reginald Warburton, that it's therefore up to him to prove that he was not intending to commit murder, i.e. intending to kill with malice aforethought. And then, of course, the golden thread was something that essentially overturned that basic principle on appeal, which said that a golden thread that runs throughout all of the English legal system is the nature of the fact that a person is presumed to be innocent until they are proven guilty, and the burden is on that of the prosecution to prove an individual's guilt according to law. This is obviously here enshrined in the European Convention. So, the presumption of innocence, while something that is very clearly enshrined in the European Convention, it is not seen to be an all-encompassing right, as we will see when we look at the case law of the European Convention on Human Rights, or the European Court of Human Rights. So, for example, the case of Salabacu versus France involved criminal charges relating to certain violations concerning customs regulations. Some of these criminal offences involve charges which were strict liability. For those of you who have not studied criminal law, I'd be a bit confused because we're doing criminal evidence here, and I assume you would have done criminal law. Strict liability are those kinds of offences that do not have a specific mens rea requirement associated with them. So, essentially, whereas most criminal offences involve being able to or having to show that two things have taken place, that a person has committed the offence, have committed the act which constitutes an offence, which of course the actus reus, and then having done so with the prerequisite guilty mind, that being of course the mens rea, strict liability offences don't require that second mens rea element, okay? And the European Court on Human Rights in this case, in fact, concluded that the idea of strict liability offences in relation to customs regulations were not expressly prohibited by the convention itself. So there is a sort of nature of these rights being not necessarily all-encompassing. And so how do we then think about this when looking at its application in English law? Well, as you can probably imagine, the English legal system has a very complicated relationship with the European Convention in a number of very important areas of adjudication. For example, try and work out why the English legal system still does not allow for prisoners, people who are in prison, to be able to vote in elections, despite the fact that this is considered to be a human right under the European Convention, and the European courts have said as such in relation to the United Kingdom, and yet we, as the English legal system, have yet to incorporate that into our rules. But the same kind of complicated relationship can be said to be true for the application of these human rights principles as they pertain to presumptions and burdens in evidence law. And one example of this is the case of Crown versus Lambert from 2002. In this case, the defendant was convicted of being in possession of a controlled substance, of a controlled drug. The defendant sought to rely on the defence that was elucidated in a particular provision of the Misuse of Drugs Act from 1971. This provision was Section 28.3bi, and essentially what he was trying to do in using this particular defence is show that he did not suspect to believe, or have a reason to suspect that he was in possession of the controlled drug. Essentially, Section 28.3bi of the Misuse of Drugs Act concerns itself with whether or not you actually know that you own the drug, or you actually have the drug about your person, in order to be convicted of being in possession of a controlled substance. In order to do this, he would have to show that, on balance of probabilities, he did not know that the bag containing the controlled substance, was in fact about his person, in his possession. There were potentially human rights challenges raised, especially when we think about Section 3.1, which requires that, insofar as possible, primary legislation should be read in accordance with the Convention rights. I'm being a little bit convoluted here in the way that the language is cited. Section 3.1 refers here to Section 3.1 of the Human Rights Act from 1998. It's not the Misuse of Drugs Act, because Section 3 of the Human Rights Act concerns the rules associated with the ways in which Parliament ought to, or at least I say the court, ought to interpret primary legislation that is passed by Parliament in accordance with the Convention rights insofar as they possibly can. And then Section 4 of the Human Rights Act concerns the circumstances in which that may not be possible, where, for example, there is a piece of legislation that is just fundamentally contradictory to the Human Rights Act, to the Convention, to the European Convention, at which point, according to Section 4 of the Human Rights Act, the courts are able to issue what are known as declarations of incompatibility. So Section 3 tells us that, essentially, where there are, let's say, multiple different interpretations of a particular piece of legislation, or even a provision within a piece of legislation that is passed by Parliament, the court is obliged, according to Section 3, to read into that legislation or into that provision the interpretation that closely fits with that of the Convention, that does not contradict that of the Convention. So let's say there's two interpretations of a particular provision. One would contradict or be in violation of the European Convention, the other would not. The courts are obliged to read into and interpret the law as to be in accordance with the ECHR. And so it was held by the courts here. The courts concluded that in order to be in accordance with the interpretative principles of Section 3.1 of the Human Rights Act, Section 28.3bi of the Misuse of Drugs Act ought to be read as imposing only an evidential burden onto that of the defendant. So the courts read into the particular piece of legislation, the particular provision here from the Misuse of Drugs Act, an interpretation of that provision such that it does not contradict the basic principle of the presumption of innocence and the basic principle of Article 6 and the defendant's Article 6 rights in accordance with the European Convention. This is all so that they can be in accordance with the Human Rights Act. They say that, quote, "It is not unprincipled to have regard to the practical realities where the issue related to knowledge in a drugs case, where the issue relates to knowledge in a drugs case." And so, as a result of which, we have seen the ways in which the European Convention, as elucidated and incorporated into English law through the Human Rights Act, has been able to make certain changes when it comes to, or at least certain interpretations when it comes to the ways in which this has an impact on the law of evidence, specifically the sort of foundational principles relating to the presumption of innocence and the burden of proof.